Senior managers. What happens to accrued and untaken holidays? Is the senior manager entitled to payment in lieu of accrued holidays not taken in respect of the current year at the time of termination, or also in respect of the previous years? When discussing the terms of termination of employment with top management, they are often told, with regard to holidays, that the employer only recognises payment in lieu of the holidays accrued in the current year, while those not taken in previous years are considered lost. This approach, however, has some reservations in light of recent case law on the subject. In particular, with regard to holidays, the law recognises also for managers an annual rest period of no less than 4 weeks, 2 of which must be taken in the year of accrual and the remainder in the following 18 months. The sectoral collective labour agreement applicable to the employment relationship may provide for exceptions and/or additions. So, what happens if the manager does not take their holidays during the employment relationship? It is noted on this point that not taking holidays cannot be monetised. The prohibition of monetisation of holidays provided for by Directive 2000/88/EC and taken up by Article 10, number 2 of Legislative Decree number 66 of 2003 is aimed at guaranteeing their actual enjoyment for the purpose of recovering the workers' psychophysical energies, a recovery which would be nullified if it were to be replaced with an allowance. The regulation of the executive employment relationship has always had an element of speciality. In fact, while other professional categories generally recognise the right to payment of the allowance for leave not taken over the years as severance pay, jurisprudence has tended to exclude such a right for executives on the grounds that the genuine executive relationship, all the more so if top management, confers on the worker such powers of autonomy as to self-assign the period for taking rest. In ruling number 18140 of the 6th of June 2022, the Supreme Court ruled that the power of the manager, including the top manager, to autonomously organise the enjoyment of their holidays, even if accompanied by obligations provided for by collective bargaining to inform the employer of the planning of activities and rest periods, does not entail the loss of the right, upon termination of the relationship, to be paid the indemnity in lieu of the accumulated holidays. Without prejudice to the foregoing, and also considering the fact that holidays are among the inalienable rights, it follows that the manager may legitimately claim payment of the indemnity in lieu of all outstanding and untaken holidays during the course of the employment relationship, subject only to the limits of the statute of limitations laid down by law. Paola Balletti, lawyer.